Ed, Nisqually, your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all caps.
Hey everyone, welcome back to today's video. We're diving into a clip from a channel I regularly follow called Time Served, which consistently shares interesting court videos. In this episode, we watch a sovereign citizen who not only repeats the usual conspiracy-laden claims, but also absurdly argues that he isn't guilty of trespassing simply because he was allegedly too drunk. It's a classic mix of arrogance and denial, making for both entertaining and jaw-dropping courtroom moments. If you enjoy content that breaks down real-life legal drama, definitely check out the Time Served channel. There's a link in the description. So without further delay, let's jump straight into the video and see how this unfolds.
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So,
According to one of Merriam-Webster's many definitions, the term people refers to a body of persons. So, if you consider yourself one of the people, then by that very definition, you are indeed a person. Sure, you might be a foolish or silly person at times, but you are still, without a doubt, a person. It's a simple truth wrapped in words we often overlook. Yet it reminds us that being part of the collective doesn't erase individual identity. Even in our mistakes or moments of ignorance, we remain members of the human community. So, take it as a gentle nudge. You're a person, whether brilliant or a little clueless, but a person nonetheless.
Okay.
have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
I have to be completely honest. This is the first time I've ever heard someone claim they were too drunk to be held responsible for their crime. Not that they didn't commit it, and not that there wasn't enough evidence to prove their guilt. No, the argument here is, yes, I did it, but I was just too drunk for you to punish me. It's a baffling defense that somehow tries to excuse illegal behavior while fully admitting it happened. The logic is both absurd and frustrating, yet it makes for one of the most unbelievable courtroom moments you'll ever witness. Moments like these really show the creativity and audacity of people trying to escape accountability.
And he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone And he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or on the assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Don't worry, your moment to shine will come. Though honestly, it'll be more like a flickering, burned out light bulb than anything bright. For now, though, it's time to step back and let the adults have their conversation. Sometimes patience means sitting quietly while others take the spotlight, even if you're eager to jump in. The scene is theirs for the moment, and your chance will arrive soon enough. It's a reminder that timing matters, and even the dimmest bulbs eventually get noticed. So hold back just a little, you'll have your turn to make an impression.
Of course.
All right, so Ms. Sharp, it appears that the assault was not a deferral, it was a stipulated order of continuance.
That's correct, Your Honor.
All right, thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. I will, and Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that.
I can neither confirm nor deny being a sovereign citizen. No, I don't have a law degree, and I won't pretend that I do. What I can admit, however, is that I spent last night sleeping outside a Holiday Inn Express. It wasn't exactly glamorous, but it's the kind of experience that keeps life interesting. So while I may lack formal legal credentials, I certainly have my own stories to tell. Sometimes reality is far stranger than any courtroom argument could ever be.
That if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment. So it is never a smart thing to represent yourself, and frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel, and if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay, you know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights This
is one of those moments where every attorney watching is probably banging their forehead on their keyboard. An experienced lawyer sitting next to you would immediately know how to request discovery because that's literally part of their job. They also understand that reading your Miranda rights isn't a prerequisite for an arrest. Those rights mostly come into play regarding anything you say after you're taken into custody. It's basic legal procedure that professionals know instinctively. Watching someone stumble through this is equal parts frustrating and eye-opening for anyone familiar with the law.
For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged.
Well, technically there were no victims, except, of course, for the people who owned and ran that 7-Eleven you refused to leave. I'm sure they loved witnessing your petulant behavior firsthand. In fact, your antics probably made for an entertaining spectacle, and who knows, it might have even been good for business. Watching the so-called living man of the liquor bottle strut around as if consequences didn't exist is certainly memorable. Your dramatic display turned an ordinary day at the store into something entirely unexpected. It's a rare kind of chaos that people can't help but notice.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights or on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole him.
That was your one real chance to argue against the state's recommendation to keep you in jail on 2 $500 bonds. Instead of making a case for yourself, you did everything except what mattered most. Opportunities like that don't come around twice, and you just let it slip away. By the time it was over, there was nothing left to salvage. Sometimes in court, timing and focus are everything, and missing the mark can be costly. In this instance, that was the end of your chance to turn things in your favor.
Rights, and I wasn't taking a statement from in both questioned cases in question.
All right, so what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right, which is one of the reasons you don't want to represent yourself, but I've explained that to you now. But I just want to make sure, so you still wish to represent yourself?
Absolutely.
Honestly, he's about as sharp as a box of used crayons. Nothing about him suggests clarity or insight, and any attempt at cleverness just falls flat. It's the kind of dullness that's immediately noticeable in a room. You watch and wonder if he even realizes how ineffective he comes across. Sometimes people leave an impression not by what they say, but by how little sense it makes. In his case, it's painfully obvious. There's no edge, no point, just a lot of wasted potential.
Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
You know, if the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible.
Oh, really? You have anti-kidnapping training? That's impressive. In theory. I'm curious how well it's working out for you while you're effectively being held down at the county jail. It's a little hard to demonstrate those skills when your current situation screams the opposite. Sometimes claims and reality collide in the most ironic ways. Watching this unfold makes it painfully clear that training only counts if you can actually apply it. Right now, your situation says otherwise.
History that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. So just, I don't
Cool.
know whether that
Well, I have
changes anything or
$100.
not.
Isn't that
Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it, but they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
awesome? In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking
they've
of,
heard
by
you,
the way,
and Mr. Sharp has heard you, and we'll go forward that
on
way.
a side note, if I may, Your Honor, during intake, and I might preface this with,
Alright everyone, that wraps up today's video. It looks like the next time we'll be seeing this particular genius will be in a couple of weeks. In the meantime, why not head over to the Time Served channel and explore their wild collection of courtroom moments. If you enjoyed the video, be sure to leave a like, and if it wasn't your cup of tea, go ahead and leave a dislike. Either way, your feedback helps the channel know what resonates. Thanks for watching, and we'll see you back here soon for more jaw-dropping court antics.